Landlording Hacks Part 9. 11 things a landlord cannot do before or after leasing out a property. See, as a landlord, you want to rent out your properties as soon as possible in nearly all cases. It's important to remember, though, that as soon as a rental agreement is signed by the tenant, there will be a list of things that the landlord just cannot do related to the property. For example, tenants have the right to quiet enjoyment, which means the landlord can't interfere with the tenant's day-to-day activities. And even if a tenant violates these terms, a landlord cannot carry out illegal eviction by moving the tenant's personal belongings without their permission. In fact, you can't even change the locks. If you are a landlord, it is crucial to follow your state laws regarding the tenant's rights and the implied warranty of quiet enjoyment. It's a legal term. Fortunately, from the landlord's perspective, it usually means the tenant has more rights to the property than the owner. Therefore, understanding what you can and cannot do is vital to running a successful rental business. So, here are 11 things a landlord just cannot do. You cannot discriminate against the tenant. You cannot enter the property without proper notice. You cannot force a tenant to leave the property. You cannot change the locks on the doors. You cannot move a tenant's personal belongings without their permission. You cannot switch off the utilities, electric or water. You cannot raise the rent arbitrarily or without following the law. You cannot refuse to make necessary repairs, no matter how ridiculous. You cannot use a tenant's space at all. You cannot prohibit service animals. You cannot refuse to return a security deposit over general wear and tear. See, becoming a landlord is an excellent way to generate revenue and income from real estate investing. As a landlord, however, it's vital to remember what you can and cannot do. You need to know what would violate a tenant's rights. This means avoiding specific actions that could break the implied warrant of habitability or the covenant of quiet enjoyment. As long as you deal with tenants within the bounds of your state laws, you will avoid potentially costly court time and lawsuits and lost revenues. So, if you want to learn more landlording hacks, well, like and follow for more.